It's April the 21st, 2016. I'm Wade Davies, and it is my honor to get to interview Tom Dillard for this project. Tom is not only one of my favorite lawyers, but also one of my very favorite people. So we're going to grill Tom a little bit this morning and see how it goes. All right, Tom, I'm not putting you under oath, but I am supposed to start out by getting you to state your full name and your date of birth.
William Thomas Dillard III, and November 28th, 1941.
And I hate to start out with this topic, but
you're going to anyway, right?
Well, you're one of the only people I know for whom being falsely accused of something has turned out actually to be a positive experience.
Yes, it was.
So I want to ask you about your alleged college rioting.
Well, it also was an early indication and example of false eyewitness identification.
All right.
I had just enrolled in the university. I was barely 18 years old.
University of Tennessee.
University of Tennessee, and happened to be up in the Cumberland area during a snowstorm in, I think it was early January. And I decided that there was a little too much activity going on up on the Cumberland, up on the Strip. So I decided to leave and make my way back to the fraternity house where I was living on campus. And I got about halfway back, and all of a sudden, a police officer and a representative of the university jumps out from behind a tree, grabs me, and throws me into a paddy wagon. And off I go to jail. So I get to jail. I'm advised that I've been charged with rioting, inciting to riot, and disorderly conduct. 2 felonies and a misdemeanor. So obviously I thought this was the end of my college life, my home life, every kind of life, as soon as I called my parents and told them where I was. 8 months later, and probably 6 or 7 court appearances, the charges were dismissed. And the officer admitted that on the stand, finally, that he had followed the wrong person from half a mile away, and that I really was not the individual he was trying to arrest.
What were you supposed to have done?
I never really knew. I was supposed to have been involved in this gathering up on Cumberland, where they were pulling cars around that were trying to go up the hill, and it was icy. And other than that, I never really knew, except the officer on the stand in one of the earlier hearings said that he was afraid for his life because of me, this little scrawny 18-year-old. And I had never seen him before, haven't seen him since. But thank goodness it worked out. But as you can imagine, every application I made thereafter, I had to put on there that I had been arrested for those rather serious offenses.
And how did that affect your career choice and really the rest of your life?
I was thinking at that time about going into the law. I hadn't made up my mind for sure. That kind of put me in the right direction. And I went into pre-law then at the University of Tennessee and on to law school.
And then as a prosecutor, you had, I guess, in your mind, the fact that sometimes people who are not guilty do get charged.
I certainly did. I think it helped level my thoughts about individuals who are charged with crimes. It certainly did as a defense lawyer. I've had a couple of occasions where I would remind a client that, well, I know what you're going through because I've been in jail myself.
What year was this?
This was probably real early 1960.
And how was the Knox County Jail in 1960?
Oh, it's a wonderful place.
Where was it?
It was down where in the area where the Salvation Army is now. And yeah, it was a memorable experience, let's say.
So after you made it through that and made it through college, you ended up going to law school.
I did.
Where did you go? And
I went to University of Tennessee Law School. Graduated in December of 1964 and took the bar in February of 1965.
did you have any classmates that became your lifelong friends in law school?
I certainly did. I knew Dan Nolan, who later became president of the Tennessee Bar. He and I were friends from probably 1959 when we both entered undergraduate all the way through. And so we've been close family friends. Robert Eccles, federal judge in Nashville, was a classmate as well and a good friend.
And what about Bob English? You had an association with him. Did that start in law school?
Just a little bit. Bob and I were roommates from 1962 when we were both in the same class looking for an on-campus or close-to-campus apartment. So we were roommates from 1962 through, I think, late 1963. And then for 50 years thereafter, we remained friends up until his death.
So what did you do after you graduated from law school?
I was offered a position in the firm of Stone and Bozeman, Harold Stone, and at that time, Judge C. Howard Bozeman. I had clerked for them in law school, and so they were kind enough to offer me a job once I got out. And I was probably in 1966, I realized that I was not really suited for that type of law. I mean, it was a good firm, enjoyed the people there. Cecil Meek was in the firm at that time, a great lawyer. I took the place of Wilson Horde, who had gone on to the U.S. Attorney's Office. But it really was like having a square peg in a round hole. I mean, that was just not the type of practice I enjoyed.
What kind of work were you doing when you first started?
A little bit of domestic work, a lot of title searches, things of that nature.
I think most people know you as a prosecutor and a criminal defense lawyer, but my understanding is you also have a little experience in the area of mobile home repossession.
That's another reason I got out of the practice, the civil practice. One of Stone and Bozeman's clients was Associates Discount, and they were in the mobile home financing business, and they had mobile homes all over East Tennessee. And every now and then, we were called upon to go escort a truck driver up to the mobile home that was where they were in default and pull the mobile home out. I had done that on a couple of occasions with no real problem. Well, I was on my way out of the firm. This was sometime probably in mid-1967. And I was showing the lawyer that was taking my place what we did in the firm when we were involved in these repossessions. So we go up to rural Campbell County on this particular one. We're in a truck that the truck driver is going to repossess the home, pull up, hook it up, take it out. So we get up to the area where the mobile home is, and we're in the process of, or he's in the process of hooking it up. These two lawyers are sitting in the cab waiting on him to finish. We're in coats and ties and just waiting for him to hook it up so we can pull it out. All of a sudden, out of the neighboring or adjacent mobile home, this woman comes out with a baseball bat. And this woman is bigger than any of the three of us. And we're all three inside this tiny cab, really, of this truck. with this lady approaching us with a baseball bat. We don't, this is way before cell phones. We have no contact with the outside world. And I'm thinking, this probably is my last contact with the outside world. She comes up to the truck, takes the baseball bat, hits the hood of the truck a couple of times, and then turns around and leaves. And, I saw my whole life pass in front of my eyes, but she got what she wanted and left, and then we left with the mobile home, and it was quite a
So you
send-off.
you did get the mobile
Well,
home?
no, we
after all
got it
that?
later.
Okay.
We did not. I'm sorry, we didn't get it that time. We were focused on getting out.
And so after that, you decided that you were not going to specialize in mobile home repossession.
Yes, that sealed that decision.
Do you, I don't know, do you remember how much you were getting paid when you first started practicing law?
Yeah, before I passed the bar, in between graduation and passing the bar, I was making $400 a month. I got a raise to $500 a month when I passed the bar.
And then, so from there, you wound up at the United States Attorney's Office. How did that come about?
Another really good friend of mine, John Kerry, the late John Kerry, who was a former U.S. Attorney as well. He and I were good friends, and he and I were having lunch one day, and I was miserable. I was just not enjoying the practice of law. It was nobody's fault but mine. I mean, the firm was good. Stone and Bozeman was a good firm, but I just was not, like I said, it was a square peg in a round hole. I just was not having fun with the civil practice. So I had lunch with John Kerry, and this situation came up during our lunch, and I said, John, I don't know what to do. I'm just not happy with what I'm doing. I'm sure I'm not doing a good job because I'm not happy with it. And he said, well, we've got a vacancy in the U.S. Attorney's Office. Why don't you apply for that? I'll help you. And I said, what does a U.S. Attorney do? And so he told me and said it's mostly criminal work, prosecution. There's also some civil work. And I said, John, that sounds great. I think I would enjoy that. And he said, well, the U.S. Attorney, John Reddy, is coming into town to fill the vacancy. And interestingly enough, it was the vacancy of Wilson Howard.
So you followed him again?
I followed him again. He had been an assistant U.S. attorney and then was offered the job out at the general counsel's office out in Oak Ridge with Union Carbide. So I went in and met Mr. Reddy, the U.S. attorney, had an interview with him. And I knew I wasn't going to get the job. I had no jury experience, a little trial experience, but no jury experience at that time. And I was fortunate enough to get the job. Thanks to John Kerry. I mean, he probably lied a little bit to Mr. Reddy about my qualifications.
So you were young when you graduated from law school. So how old were you by the time you got hired on at the U.S. Attorney's Office?
Well, I had just turned 23 when I graduated from law school, and that would have been shortly after my 26th birthday. It was November of 1967. No, it was a little bit before my 26th birthday, so I was actually 25 when I got hired.
So you would ask John Kerry what an assistant U.S. attorney did, and I guess you found out. So what kind of work did you do when you first started out?
Well, there were only 3 of us in the Knoxville office. There were 2 or 3 in the Chattanooga office. Most of what we did in the Northern Division, and we covered Greenville and Knoxville mostly. We did go down to Chattanooga on occasions and to Winchester, but for the most part we did those 2 divisions. And probably 90%, 80 to 90% of what we did at that time were moonshine cases. We would have 40 or 50 on the docket in Greenville every time we'd go up there for the term of court. We didn't have nearly as many in Knoxville. We had your normal selection of bank robberies and mail fraud and wire fraud cases, but Greenville was, to a large degree, moonshine cases.
How'd you do in those cases?
We won most of those, yeah. I remember losing one in Winchester. We had a situation where the revenue officer had a camera and took pictures of the guy in the still site where the mash was being produced. And took pictures of him. This was in the dead of night. And he's taking flash pictures of this guy as he's running away from the site. Had him dead to rights, and the defense called Shirley Majors, John Majors' dad, who was just a saint down in that area, and jury came back not guilty. That's one of the few cases I lost as a assistant U.S. attorney.
Sometimes I think lawyers in my generation don't really have a real understanding for how many cases you actually tried back then. But I mean, what kind of trial schedule did you have?
In Knoxville, I can remember several times we would try 2 in a day. We'd at least start the second one in a day, and we were trying cases. Probably during the term, we had terms of court back then. And in Knoxville, we'd try 5, 6, 7 during the term of court. In Greenville, we'd try probably more. And most of those were moonshine cases, although there were some of the other criminal cases as well. But we were in court all the time.
Now, I think there was a short period of time when you left the U.S. Attorney's Office basically for political reasons. How did that work back then?
Up until, well, when I went into the office in 1967, up until that time, when the administration changed nationally, not only did the U.S. Attorney leave, but in this district, the assistants were also asked to leave. So I came in 1967 under a Democratic administration. When it changed in 1969, early 69, all the assistants thought they were, it was just a matter of time that they were leaving. So I decided I'd go look. I'd do a little preemptive strike here and see what was out there. And Wilson Howard,
once again,
Wilson Howard offered me a job in the general counsel's office at Y12, which I took. So I've been following Wilson at this point all my career. So I go out to Y12. John L. Bowers becomes U.S. Attorney. I'm once again a square peg in a round hole. Nope. Wilson was great to work for. The other attorneys and staff out there were fine. But again, I was just not in best place for me or for them. So I contacted Mr. Reddy, and thank goodness he still had my credentials in his desk. And so he said, yeah, I'd like to have you back.
So you hadn't even been gone long enough to lose your spot as a
No,
federal
it was
employee.
like 6 weeks. So as far as the Department of Justice is concerned, I never left because he still had the credentials. He'd never turned them in.
And then tell us about how you became a magistrate judge.
Well, I came back in the office, that would have been 69. we continued, or I continued in the U.S. Attorney's Office, and then in 1976, by that time, or up until that time, there were only part-time magistrates here in the district. They handled basically first appearances for criminal, for arrests, things of that nature. That was about all they did, and they were strictly part-time. Harv Duggins was the magistrate here, the part-time magistrate. Well, Congress passed the law allowing for full-time magistrates, and our district qualified at that time for one. And the judges got together and decided that to ask me to be the first full-time magistrate for the district, and that was in probably September of '76. I became the first full-time magistrate. The job back then was quite different than it is now. I mean, I did very little other than the first appearances. We took that over. Most of what we did at that time were black lung and Social Security cases, and we had an enormous amount of those. And this was before computers. We had an electric typewriter, and we finally got to the point where most of the body of the opinions that was the same regardless of what the case was, we could put into that electronic typewriter. But we had 60 or 70 of those a year between the districts. Knoxville and Greenville were the main sources. So that was a lot of what I did. I didn't do anything near what the magistrates do today. I went to, besides Knoxville, I went to Chattanooga. Judge Wilson back then, what I did for him was do pretrials in civil cases. I went to Greenville for Judge Neese. I went, obviously here in Knoxville, I did some things for Judge Taylor, and also handled the Great Smoky Mountains park cases twice a month. So I was on the road quite a bit.
So why would you leave a judicial position?
Once again, it turned into basically a law clerk's position. And there was no trial work, really, and I missed trial work. And Judge Neese understood, and I think Judge Taylor understood because his law clerk at that time was Bob Murrian. Mm-hmm. And, you know, for the good of the district, I left and Bob Murrian came on, who became a terrific magistrate judge. And Roger Dixon became the magistrate in Chattanooga. So I went back to the U.S. Attorney's Office. John Kerry, who had gotten me into the U.S. Attorney's Office to begin with, was now the U.S. Attorney. And he recruited me back in to the U.S. Attorney's Office, and I went back in as chief assistant.
And that was in the early 80s?
That was in 1978.
Oh, 78.
Mm-hmm.
So I know you've been asked this question a lot, but so how did a young prosecutor from East Tennessee become the United States Attorney for the Northern District of Florida?
I can tell you as best I can. In I think it was 1981, the Justice Department decided that they needed to, they'd been evaluating all of the offices, but they had not done the evaluations with field assistants. They had done it out of Washington. So they inaugurated this process of having senior AUSAs go out and evaluate other offices. And so I was selected as one of those. They still do it these days, but at that time, you went out and you were the only person that went out. It was a one-person audit or evaluation of another office. Now they send a team out. Mm-hmm. So I was assigned 6 districts. I was assigned all 3 districts in Alabama, northern Florida, middle Georgia, and South Georgia. Those, I think that's 6. I was given another one, but the U.S. Attorney tragically died, and so that one was taken off for this particular evaluation period. So
you evaluated the U.S. Attorney's office?
Yes, we would go down and evaluate those offices. Now, this was a time when there was a change in administration, so some were going out, some were coming in. I was advised that by the Executive Office for U.S. Attorneys just to be careful, especially in the Northern District of Florida, that there had been all kinds of problems in that district, and they were really wanting to know what the recommendations were there.
And did you find some problems?
I found some problems. Yes, I did. Probably can't go into them, but yeah, there were problems.
And so, how did that lead to your appointment?
That was in '81. Sometime later in '81 or in '82, I had been at a gathering. My cousin, who lives in Florida, had a gathering of relatives and friends, and one of his friends was the new senator for Florida, Paula Hawkins. And she finds out that I had evaluated that office, and she was also alerted to the fact that there were problems. So she engages me in a conversation down there about the problems in northern Florida. So we had a pretty candid discussion, and that was it. So I come back home, and several months later I get a call from her administrative assistant. I first thought it was a crank call, but when I realized it really was, he said, Senator Hawkins enjoyed the conversation that she had with you, and in fact she would like for you to consider letting her put your name in along with several others for the appointment to the U.S. Attorney's Office in the Northern District of Florida. Well, I didn't think that was ever going to happen, so I said, sure.
Did you have any political pull?
No, I had none.
All right.
I had none. I was totally, the Hatch Act kept us from being involved in politics, so I said, sure. Just, I was thinking, no, this will never happen, but I'm not going to turn down a U.S. senator. Well, lo and behold, I get a call a month or so later, and this is now, we're into July, and she says, I think if you're willing, I would like for you to let me put your name in as my nominee for the job. And so now I'm faced with the reality of leaving a job that I'm pretty well secure in to go to an environment that who knows whether they want me down there or not. But it was such a challenge, I thought, I can't turn this down. I'll look back on this and wonder what would have happened.
So you were appointed by President Reagan?
I was appointed by President Reagan.
Moved down to Florida. Right,
and took office in probably February of 1983. I was Judge Stafford, the chief judge down there, whom I had interviewed a couple of years before. He was gracious enough to court appoint me until the process was completed for the presidential appointment. But Senate confirmation took place sometime in early '83.
Are there any cases that stand out in your mind that you handled while you were down in Florida?
One that stands out most in my mind is the Pensacola abortion clinic bombing case. This was in 1984. In Pensacola, there were, I think, 3 abortion clinics that were blown up in over a period of months. We tried the latest one, probably as I recall, because the law of insanity changed after Reagan had gotten shot. And so the later one put the burden more on the defense than the earlier standard. And we tried that case if I recall, in the summer of '85, spring or summer of '85. And it was covered nationally and internationally at that time. And it was an intriguing case. It is just so fortunate nobody got injured or killed as a result of that bombing.
What were the defendants like?
The defendants were 18 to 20-year-old, just your classic, good kids, good grades, just some people on the outside that you would think were just ideal. And they had basically been brainwashed by a church down there and were placed into this position as a result of that brainwashing. But to this day, we're not sure who built the bomb, because nobody with as little expertise as they had, which was zero, could have put together the explosive device that was used to level this clinic. I mean, there was nothing left of it. And we could never determine who actually built that particular device. We were pretty sure they didn't. Mm-hmm. And to the credit of the ATF, the Alcohol, Tobacco, and Firearms Division, when they were on the scene, there wasn't a piece of that bomb much bigger than my thumbnail. And they put that device back together in order to determine what type of device and where it would come from, and for use at trial. They actually reassembled it, which was to me just simply amazing that they could do that.
How did you end up coming back to Knoxville?
Well, again, my position was political at that point. The administration was changing. The senator was running for re-election, and I had been thinking about coming back to Tennessee. I didn't know what I would do once I got back here, but I really missed East Tennessee. And lo and behold, my good friend Bob Ritchie, who I had tried cases against and lost early in my career, he had come down a couple of times, once because he had a client that was in the Tallahassee Federal Correctional Institution. And he'd stop by and see me. And another time he came down, and strictly to see if he could talk me back, coming back to East Tennessee. And it didn't take much effort, because I was just so ready to come back, and to have an offer from Bob to come back didn't take much persuasion. I was delighted to come back and work with Bob.
So you mentioned trying cases against him.
Yeah.
Any of those come to mind?
Yeah, one really sticks out. It was a wiretapping case where the husband had been wiretapped by the wife and a private detective and an attorney. And so we had indicted and were prosecuting the private detective and the attorney. And the husband was our prime witness, because he was the one that was the victim of the wiretap. we're going along well in trial. We're into the second or third day of the trial, and in the old courthouse in Greenville, the U.S. Attorney's suite overlooked the street. And I'm getting ready for trial, and I happen to look out the window, and I'm looking down, and I see Bob's car pull up, and I see my prime witness get out of the passenger seat. And I'm thinking, this is not good.
And how did it go?
It was not good. We managed to convict the private detective who was the main person, but the Bob's client was acquitted.
So that was a big change when you came back. So what was it like going from prosecutor to defense counsel all of a sudden after that many years?
You know, I think that after the initial shock, and I can remember Bob and I were trying a case in front of Judge Jarvis. This was soon after I got back, and I'm getting ready for start the trial, and the Judge Jarvis asked if the prosecution had anything further to say, and I'm about halfway out of my seat, and Bob reaches over and grabs me. But other than that, the change was really not that big a deal. I think a lot of that was working with Bob early on, and Charles Phelps, who was also a former prosecutor. I mean, for a short period of time, we were in the office here in the Eastern District of Tennessee together. And to have those two individuals with the class and professionalism that they brought to the table, I just felt, again, extremely fortunate to be a part of that group. And there really wasn't that big of an adjustment, because all you're doing is changing clients. And if your whole idea is to do the best you can for your client, if your client's the United States, fine. If your client is John Smith, you do the same thing to the best of your ability.
You get some interesting fact patterns in this line of work, so I want to ask you about just a couple of those. You ever have a case that involves something interesting falling out of the sky?
Yes, it was an individual and about 100 pounds of cocaine. This was an individual named Andrew Thornton, not my client, but Andrew, and this was in the early 90s, I believe, early to mid 90s. This elderly individual in South Knoxville looks out his window and in the driveway sees this crumpled up individual wearing a parachute, and at that time he didn't know it, but quite a lot of cocaine. And he calls his daughter and tells her what he sees out in his driveway. She doesn't believe him, and she just says, "Oh, Dad, go back to your pablum," and whatever, Turns out that what happened, Andrew Thornton, who was an experienced skydiver, had ferried a load of cocaine and was going from somewhere in South Florida back to Kentucky when the DEA intercepted him, and he put the plane on autopilot, jumped out of the plane, unfortunately with more of a load he should have known, but greed got the best of him, and then the asphalt got the best of him, and he died right there in the driveway. And then that started an investigation, and his girlfriend at the time was waiting for him over in the Hyatt, which is now the Marriott, totally unaware that what he was doing, but she thought he was at a skydiving competition in South Florida, and they were going to meet in Knoxville and go back to Kentucky. She ends up getting investigated and indicted for aiding and abetting Andrew Thornton in this massive cocaine delivery. A very interesting case. It turned out upon investigation by our office that there was another individual in that plane who also was totally unaware until he got in the plane of what Thornton was doing. And when they get intercepted by DEA, he's in the plane. He has never jumped out of a plane before. And here we are at night. And so Andrew Thornton says, strap on this parachute. You're going to have to jump out of this plane. Well, this guy had a military background, but it still scared the living daylights out of him that he's going to have to jump out of this plane. As he is getting prepared to do that, Thornton says, one thing you got to do, please meet my girlfriend at the Hyatt. She doesn't know anything about what's going on, but she's going to wait there until I get there, and I'm not going to be able to meet her. Just tell her I'll see her back in Kentucky. And again, don't tell her anything about this because she doesn't know anything about it. That conversation was not known to the government until we tracked down the other guy that was in the plane. He did jump out. He managed to survive the jump and got over to the Hyatt and informed Thornton's girlfriend about what happened. And then they end up back in Kentucky. But it was a most interesting case, and it got headlines here for quite a while because without that piece of information, the government thought for sure she was there waiting on him.
And the case against her ultimately got dismissed.
It got dismissed, yeah.
Going back to your days as a prosecutor, how about did you ever see a defendant show the jury anything unusual?
This one is really, truth is stranger than fiction. And I do have an attorney who can be a witness to this, can verify this. Mike Haynes, who's now a partner over at Hodges Dowdy in Carson, had just come into the U.S. Attorney's Office, and so he was second chairing this case with me, and it's a bank robbery case. The bank robber is on trial with appointed counsel, and right off the bat, the attorney or the defendant is not happy with his attorney, and Judge Taylor is not happy with his attorney because the attorney is taking much too long to voir dire the jury. Judge Taylor thinks it probably should have been done in 5 minutes. There were certain questions that the defense attorney wanted to ask, and Judge Taylor kept telling him, go on, and finally Judge Taylor, in a, not just a stage whisper, but fairly loud, said, you act like you don't know what you're doing. So the poor attorney goes back to his counsel table, and the defendant's leaning over, talking in his ear, and then the attorney gets back up and says, Judge, my client heard you say that I don't know what I'm doing, and he wants an attorney who does know what he's doing. He wants another attorney. Judge Taylor says, just do the best you can. And I turned to Mike and I said, it doesn't matter what happens from here. We're going to try this case again. So we get into the case. Judge Taylor is feeling probably a little sorry for this attorney. And the client's defense is he could not have been the one that our witness said robbed the bank because the witness said that he jumped over the little gate, you know, the teller gate, to get back where the tellers were. The client's defense was, I had a hip operation. I'm lame. I couldn't have jumped anywhere, anything. So it's afternoon. Judge Taylor is a little tired, feeling sorry for this attorney. The attorney gets up and says to the judge, Your Honor, my client would like to show the jury his scar. Judge Taylor has no idea where the scar is. So he says, typical Judge Taylor, get on with it, sure, go ahead, just hurry up. So the client, the defendant, gets down from the witness stand, marches down in front of the jury, turns around and drops his pants. Moons the jury. And you can hear this collective gasp. Ah! Judge Taylor never knows what happened. And all I can see, because I'm over here and the jury's over here, all I can see is the defendant with this grin from ear to ear. He's got a story he can tell. So, lo and behold, puts his pants back on, gets back on the witness stand, proof ends, the jury's out, I think long enough to elect a foreman, and they come back, a matter of minutes, and they find him guilty. One reason was when he got back on the stand, he hopped up the step.
He was so happy with what he did.
He was so happy with what he did. He hopped up to the step, which blew his whole defense. And so the jury was out a matter of minutes, and they came back. And I can remember Mike Haynes, this was the first case he'd been involved in. And as an assistant U.S. attorney, he turns to me and he says, "Does this happen all the time?" I said, "What, Mike? This is normal." So, but that was the first and only case I've been involved in where the defendant mooned the jury.
One of the things I've always admired about you is your relationship with your wife, Susan, and how interested you all are in each other's lives. And so, has Susan ever caused any of our clients to receive a certain nickname?
Yes, and Susan has been a terrific, helpful influence. I've done openings and closings with her and her comments and edits and suggestions. And on occasion, she has, at my suggestion, helped clothe and dress defendants. Because, as you know, especially in the criminal practice, if you leave a client or a witness just to dress the way they normally do, there's no telling what you would get. In fact, just as an aside, I was prosecuting a case, a counterfeiting case. And the witness, who had received the counterfeit bill was working in a bar, a nightclub, because that's where a lot of counterfeit money goes, because it's dimly lit. You're not going to be able to tell that that's Pluto on the $20 bill. And so we called her as a witness. Well, I meet with her, get her testimony down, and I said, make sure that when you come to court, you dress in your Sunday go-to-meeting clothes. That meant one thing to me. She'd never been to a Sunday go-to-meeting. And so she had kind of the idea that it was supposed to be special. So she comes in this bodysuit almost. I mean, she's got the, I don't know if you remember the White Owl girl, but she's got this very suggestive dress and outfit on. That was her Sunday go-to-meeting. I don't know who she was meeting, but there's my prime witness. Fortunately enough, there were enough males on the jury that it probably worked, but that taught me that you just don't turn them loose to dress the way you think they're going to understand. So all that being said, Susan, being in retail management and with degrees in fashion merchandising, pretty well suited to help us out. And so you and I had this case with this young girl, and we didn't want her dressed like she would dress going to a class at college, we wanted to impress the jury with how innocent looking she was. And this is a vehicular homicide case. So with Susan's help, we dressed her and we got a favorable verdict. The prosecutor comes up during the trial to us and says, where's your staff? And we were like, what are you talking about, our staff? You mean our office staff? Why would they be down here? And he said, no, Little Bo Peep, your client. Where's the staff that she's supposed to have?
I'll never forget that.
But it worked.
So you've represented from time to time some pretty rough characters. And what's it been like to be around people that no one else wants to be around?
Well, I guess the first one kind of brought Matthew 25 home to me, and that is that there, you may see Jesus in places you didn't expect him, and it's probably a good thing to keep in mind when you're on death row interviewing a client. And I've been down there a couple of times, not on individuals, let me say, that we tried and were convicted and sentenced to death, but ones that we were appointed to on post-conviction matters. And it's probably to me, the most unsettling of any situation, because if you're on death row and they bring the client to see you, they first put you in a cell. It's smaller than this room. And obviously there are bars all around it. The guard comes with the client who's shackled and handcuffed. And there's a partition in the jail cell, and once the prisoner is in the jail cell with you, the prisoner turns around. The guard's on the outside. He's smart. He's out there. The prisoner puts his hands out and the shackles and handcuffs are taken off. And so now you're, like we are, face to face in this small cell, and the guard has gone off. He's nowhere to be seen. So you're sitting there. In one case, I'm sitting there with an individual who has been convicted and sentenced to death for stabbing 3 people to death. And that's rather a tense moment, because you're not sure, even if you did alert the guard, that he could get there before something really bad happened to you.
And despite that tense beginning, how has your relationship with those people turned out?
I can honestly say it's been good with those people. The one that I mentioned, we had a pretty good relationship for 10 or 12 years after that, and he was, there's still a person inside that body, and there's something you can relate to, even though they've done horrible things, and I think that that's something that a lot of people miss, that some prosecutors do understand, that it's not just a thing that's being prosecuted. It's a human being with family, with a body and a soul.
Not to stretch the death row theme too far, but do you have any last words? Or maybe too stretchy.
Can I get a last meal? My last word is I'd like a last meal. My last words, I guess, would be I really appreciate this whole process, and I'm humbled that I would be selected as part of this video history project. And so many times I've watched a lot of these, or several of them, and the last question is, how would you like to be remembered? And I think the last words I would want is, I would like to be remembered. Remembered, that's up to the individual whose memory you're tapping into. I would hope that at the end of the day, I'd be remembered as being loyal to family, loyal to the firm, loyal to the clients, and loyal to the profession.
Well, having spent the last 25 years with you, I can assure you that you will be remembered, and you have inspired actually generations of lawyers who are coming up, and I can't thank you enough.
Well, thank you. I appreciate it. Thanks.